I ngā mana, i ngā reo, i ngā iwi o te motu, i ngā manuhiri, i ngā hoa mahi kua taimai nei I tēnei rā, nau mai, haere mai ki te whariwānanga o Otago, not say the wrong one. Nō reira, tēnā koutou, tēnā tātou katoa. A very warm welcome here this evening from the University of Otago Legal Issues Centre. We're really delighted to have a lovely audience to listen to our topic here this evening on whether online dispute resolution is our legal future. My name's Bridgette Toy-Cronin. I'm the Director of the Legal Issues Centre. And we want to extend a very warm welcome to everyone who's come to listen tonight, and a special mention to the people who have travelled to be here tonight. Our speakers who have come from Melbourne and from Auckland, to our donors to the centre who were very generous in founding the centre from Christchurch, and our board of advisors, many of whom have travelled here tonight as well. A couple of housekeeping things. The exits are at the back of the room. Go down the stairs if there's an emergency, and there's bathrooms out in the foyer as well. At the end of the talk tonight, we're going to have refreshments available in Seminar Room 5, which is just across the foyer, so we invite you all to come and join us for that. That's just a tantalising thing to keep you all going for a bit. So we're doing a live broadcast tonight via the web stream for the university, and because of that we need to be careful with miking so that people who are listening from afar can still hear everything. So for question time, what we're going to do is there's pieces of paper and things that have been put around the room. If you've got questions during the talk tonight, if you can just hand them up to the end of the row, and what will happen is we'll collect them up, and Ali Cunningham, who's with the Legal Issues Centre, will read them out to the speakers at the end, so that we've got lots of chance to ask lots of questions and everyone can hear both the question and the answer. Right, so without further ado, I want to introduce our speakers this evening. So we've got Katarina Palmgren, who's come from Melbourne to join us here tonight, as I said. Katarina's originally from Sweden, but is a graduate of the University of Western Australia, and she's at the Magistrates Court of Victoria. And Katarina was given a Churchill Fellowship to look at online dispute resolution around the world, which is a very prestigious fellowship to investigate developments in other countries. She's also spent time working in the international legal field at the ICTY, ITCR and the ICC, so those are the international tribunals and criminal court. And in 2017 she undertook this fellowship program, so she's going to share with us tonight the motivations for that study and also its findings. And then some of you might know Heron QC, who's a QC in Auckland. He is a leading practitioner in commercial and regulatory litigation and arbitration, and formerly New Zealand's Solicitor General. He's appeared as lead counsel in all the New Zealand courts, including the Privy Council, when it was that, as well as select committees, the Waitangi Tribunal and other tribunals. Oh, sorry, Andrew, it still is for some cases. He's correcting me from the cheap seats. He's also conducted significant commercial arbitrations for both the Crown and corporate clients. And in 2016, he founded CODA, which is an online dispute resolution service. And so he's going to bring tonight the New Zealand perspective on what's happening in online dispute resolution here in Aotearoa. So without further ado, I welcome Katarina to talk to us about the international experience.
Asked to do that discreetly, which was kind of hard. I'm going to start by saying that I got a throat infection last week, but I have assured Michael I'm not contagious. And I've been on a lot of antibiotics, and this week I said to the doctor that I'm speaking in New Zealand, I can't lose my voice and I don't want to cough, so he gave me some steroids and said that this is what we give to singers and performers, so you should be able. So hopefully I'll make it through. I would like to start by thanking the University of Otago's Legal Issues Centre for having me here today, and especially Ali and Bridgette. I'm excited being here talking to you in New Zealand about ODR and online courts. So I work at the Magistrates Court of Victoria in Melbourne, Australia. And the Magistrates Court is the lowest court in our jurisdiction. So I believe it's kind of like your district court here. So we have civil jurisdiction up to $100,000. Yours is higher, I believe, to $350,000. And we also don't have a lower threshold that you have here. So we deal with all matters, all civil matters from 0 to 100,000, basically. We also have very similar criminal jurisdiction to what you have here. So in my role, I am a court legal advisor, which means that I work in the magistrates' chambers. So the magistrates, the judges, we just call them magistrates in the lower court. So I work as a court legal advisor to the Chief Magistrate of Victoria and the Greater Magistracy of the court. So in this role, I get a lot of varied legal questions, both coming out of court proceedings and questions that have to do with the administration of the court. So it's in this capacity that in early 2015, the Chief Magistrate came to me and said, can you please look into whether there is such thing as a fully functioning online court in the world? That is there any jurisdiction in the world that has an online court that is fully integrated into the public justice system? So the reason why the chief came to me with this question was that we had just received the final report from a consultancy company that had come in to look at our operations, and they were looking into how we could best modernize our court and our processes and operations. And one of the recommendations in this report was for all matters, civil and criminal, to be instituted online, and for all small civil claims to be funneled into an online court. And that was the end, that was just the recommendation. And when they say small civil claims, I assume they mean all claims in our jurisdiction up to $10,000, because they are currently dealt with in what we call arbitration, which has relaxed procedural rules. And I know it's slightly different here in New Zealand, how you have the dispute tribunals. They deal with all matters up to 15,000, I believe, from what I've learned. But that was the recommendation we got from the consulting group. So having been asked this question, I started looking into online courts, and I found that there was no such thing as an online court in the world. And I also, that still is the case. There is no such thing as a fully integrated online court in the entire world. However, I quickly learned that there is a lot going on. So although there's now a fully integrated online court, I learned about the concept of an online court, and I learned about online dispute resolution, or ODR. I learned that Canada has the Civil Resolution Tribunal, the CRT, which is a fully integrated online tribunal. I will speak more about that shortly. And I learned about the blueprint for an online court that has been developed in the UK. And I also learned about the myriad of organizations, legal service providers, and government authorities around the world that are using ODR. And I learned about the many courts and tribunals that are using some aspect of ODR and are working towards the goal of implementing a fully integrated online court in their jurisdiction. I also learned more about access to justice issues and why we really need an online court. And in Australia, the Australian Productivity Commission has said that about 15% of our population has an unmet legal need that they can't do anything about because they don't have the means. They can't afford a lawyer, or the sum in dispute is simply disproportionate to getting a lawyer. So if you have an unmet legal need and you can't afford a lawyer, basically you have two options. One, to do nothing at all. And 15% of our population do nothing at all because they feel they can't go to court. And 15% of the Australian population, that equals about 900,000 people, so almost 1 million people in Victoria, so my state alone, that have unmet legal needs. If you decide to do something and go to court and represent yourself as a self-represented litigant, this is often an experience that is complex, quite daunting, stressful, intimidating, and can be quite an outdrawn process. So, and also if you represent yourself and you're not quite sure what you are doing, you are at the risk of an unjust outcome. So having learned all of this, I went from someone that was quite skeptical to the idea of an online court when I first heard it, to someone that became quite excited about it. And the reason why I was skeptical about an online court is I spent most of my career, as was said, working in different courts and with the judiciary, so I'm quite conservative. And I take quite a conservative view on the question as to what is a court. And I also am very cautious and even distrustful of anything that I fear would infringe on due process. But yeah, having done all this research, I became quite excited about an online court. I started to learn and understand the potential. I feel like I lift this up a bit. Yeah, I started to learn and understand the potential of an online court and how we live in a time where courts, like other sectors in our society, have the ability to leverage technology to increase access to justice and access to courts. I started to understand that there is no reason why the process of going to court has to be so complex and, quite frankly, intimidating to people, at least not in relation to small civil claims. I point out here, when I talk about an online court, I'm talking about small civil claims, not complex matters. Far from all matters lend themselves to an online court. And I'm not talking about civil litigation in the higher courts, complex litigation. I'm talking about simple civil disputes. In Canada, a fellow common law jurisdiction, the Chief Justice of Ontario, Justice George Strappy, stated when sworn into office that we have built a legal system that has become increasingly burdened by its own procedures, reaching a point that we have begun to impede the very justice we are striving to protect. Shannon Salter, the chair of the CRT in Canada, has said that we must look at what parts of the processes are necessary to achieve a fair resolution between parties and which parts are merely holdovers from a bygone age, a matter of habit rather than necessity. In my view, the online court presents a modern, efficient, simple and user-friendly way in which to go to court and resolve your disputes. And this modern online court does not take away from the authority of the court or impede on due process. It does, however, relax the process. It uses plain language and makes it easier for people to resolve their disputes from the comfort of their home without the need to travel to a physical court. So, having learned all of this, I think it's a question of when as opposed to if we're going to do it. So it was with this in mind that I applied for a Churchill Fellowship to look into what's going on in the world and how we can best, or how ODR is used around the world to resolve small civil disputes and how we can best integrate an online court in Victoria. What I do, I'm going to go through quickly exactly what an online court is, but first I was just going to say that what I really wanted to do with the Churchill Fellowship was that I wanted to look into when we do it, what do we need to do it right. I think it's very important that we get it right from the outset. Governments are not very famous for successful technology projects, so I thought we need to look into all the different aspects and not have a half-baked concept to really understand what we need to look at. Because there's many questions, both legal, technical, operational, and financial matters that need careful consideration before you can implement an online court. So I will briefly touch upon some of these, just mention them, and then if there's anything that you're interested in, maybe you can raise it in the Q&A later. So issues that we need to look at include government support, bipartisan long-term commitment, not short-term pilots that lead to nothing. The jurisdiction and the appropriate subset of cases to go into an online court, the development and design of the platform. We need other people, not just judges and lawyers doing this, otherwise it's not going to be a very user-friendly platform. Technological considerations such as whether systems are to be bespoke and built in-house or whether we should get them off the shelf. Security and privacy concerns, of course. Legal considerations includes reform of rules and procedure. We have to look at court fees and costs, whether to restrict participation of lawyers in the online court. Different jurisdictions take different views. I personally see no reason why we should restrict the participation of lawyers if they are available to a court user. There's question about potential rise of speculative and vexatious claims, about power imbalances in the online court, service of document and electronic communications, the appeal process, provision of evidence online, can we limit what can be uploaded on the platform, and importantly, how do we uphold the open court principle if we're moving on to an online environment. Procedure fairness concerns arise, and also how do we gain trust in an online court. Operational considerations includes the roles of facilitators and staff handling the intake in these matters, and importantly, digital inclusion. What happens if we make an online court mandatory? What happens to those that can't access the internet or feel confident navigating an online process? So all these things has to be considered. So I was asked to look at the state of play in the world, and before I do that, I would just go through quickly what is online dispute resolution and what really is an online court, because I think a lot of people, as myself, when I first heard about it, I found this online court, I'm not sure about it, and people think about things being done online without any humans and avatars deciding your cases kind of thing. So it's not AI, it's not artificial intelligence, not yet anyway. It's much more simple than that. So online dispute resolution, what is it? Simply put, online dispute resolution, ODR, is where the dispute resolution processes are conducted online as opposed to in a physical court setting. That is to say, the dispute resolution process, be it litigation, arbitration, mediation, facilitation, or negotiation, is conducted entirely or largely online as opposed to in a physical setting. ODR has its origins in e-commerce. PayPal and eBay both have extrajudicial private redress processes, and it's well documented that eBay solve about 60 million cases a year using ODR, so these matters never go to a court. The use of ODR has since its inception expanded well beyond the realm of e-commerce, and is used by private companies and governments, non-profit organizations, and courts around the world. So what then is an online court? Much as the name suggests, it requires the ODR system to be integrated into the court system with judges or judicial officers ultimately making the decisions should the matter go through the entire process and reach the adjudication stage. What is revolutionizing about the online court is that it doesn't simply replicate the traditional court system into an online format. Instead, it radically reforms the whole court process, or the civil court process, by focusing on early dispute resolution as opposed to your day in court. So the aim is to have the matter resolved as quickly as possible with as little involvement by the court staff, facilitators, and judges as possible. So the online court model is an end-to-end process that constitutes 4 stages. So they are online, they're called different in different jurisdictions, and now when I'm going through it, this model is basically what is used in or created by the CRT in Canada, and it's very much the same as the blueprint that has been set up for an online court in the UK. So it has 4 stages, being online evaluation or exploration, whatever you want to call the first stage, online negotiation, online facilitation, and online adjudication. So I think the best way to describe it is think about it as a food pyramid, and all the matters enter the process in the bottom, online exploration, with the aim to resolve as early as possible, not having to go through all the steps all the way up to adjudication before a judicial officer. So online evaluation, the first stage, and this is the revolutionizing stage, that it changes the way the court operates. So it allows the public, if you have a legal problem or believe that you have a legal problem, it allows you to go online, and you don't have to institute proceedings in the court. So at this point, the court don't really know who you are and what you are doing, but you're using the online platform. So you log on, you just go on, and you follow a guided pathway system. So it's more or less a series of questions and answers that takes you through to a final page to provide you with legal information as to your dispute. So it sets out what your dispute is and what you can do, what your rights and obligations are. And this allows you, this meaning if you don't have access to a lawyer and you're not quite sure about your case, this informs you and educates you about your case and allows you to decide whether you're going to proceed with the matter or on how you want to proceed with the matter through the court. It also provides tools such as letters, template letters. So you might have a conflict with your landlord, and you find out that let's say the landlord had told you that no, you cannot sublet your apartment in accordance with this and this legislation, but then you have found out that is correct. However, you can if it is a close family member. So, and there is a close family member that you want to sublet to. So that could be the situation, just a simple situation. So then it provides you with a template letter that you can send to the landlord, setting out your legal position, all in plain English. And this is to try to have them resolve the dispute at this early stage, not having to escalate it through the court system. So it's giving the court user the legal information for them to understand their case and their rights, and the tools to try to settle the dispute at this earlier stage. It can even be that someone uses this service and realize, well, I think this is very unfair, but I clearly don't have a case. And this, although it might be disappointing, at least people know at an early stage before they spend time and money going through the system and using the overburdened courts that they don't have a case. If this early stage doesn't assist in to resolve the dispute, it goes on to online negotiation. This means that at this point you will have to file a complaint with the online court, which institutes the proceedings. And then the other party has to be served. And once they're served and you're both on the online platform, you can immediately start negotiating and try to resolve the dispute. So you don't have to wait for a future court date. You can try to negotiate online and solve this dispute, still without any involvement of any court staff. What this hopefully does is allow for a conducive environment, online environment where people can negotiate, and hopefully more people will come to the table and there will be less default judgments. I said earlier today when I was talking to Ali, I said in Victoria we have about 48,000 civil claims filed in a year. Out of those 48,000 cases, about I think about 18,000 cases are default judgments, and almost the same amount are struck out because people don't come to the court and file a defense and don't do anything. So having people come to the table at an early stage and negotiate is the aim of this negotiation stage. If this fails, it moves up to the facilitation stage, and at this point we have court-appointed facilitators that basically try to help the parties, much like mediation, but they're court-appointed and they're called facilitators, to try to help the parties to resolve the dispute. They have a more of an inquisitorial role, an advisory role, and can reality test the parties, and a bit like what we at least call early neutral evaluation, say that this claim is probably not going to stand up before a magistrate or a judicial officer. So try to help them resolve the dispute without having to proceed to adjudication. If all fails, then you go through to adjudication. So then you come before, or you don't come before, your matter come before a judicial officer who will decide the matter on the papers. Now, if it goes all the way to adjudication and a magistrate, which would be a magistrate in Victoria, has to decide the matter, at this point you have gone through all these stages, so the issues in dispute will be narrowed down. It's very different from when people enter the courtroom for the first time and they just start talking about issues that are probably not that relevant to the dispute and what the judge needs to hear. So it narrows down the issues in dispute, narrows down the facts, and also have the clear submissions from the parties and evidence that is put to the magistrate who can decide on the papers, decide online. If, I keep saying the magistrate, obviously it depends on what court, what jurisdiction, but if the judicial officer decides that, no, this is too complicated for me to decide on the papers, or I want to test these credibility issues and I like to test the evidence or cross-examine the witnesses, they would have to have the powers to transfer the matter back into a courtroom. So that is how an online court would work. And at the CRT in Canada, they're saying that about 80% of the cases are resolved in the facilitation stage. And that's kind of the same number that they hope to be able to solve in the UK at that stage, if the UK ends up implementing the online court that they have been talking about. So the state of play in the world, as I've said many times, there is no online court, but we have the CRT in Canada. In addition to CRT, there's so many courts and tribunals and organizations that are looking at using ODR or are currently piloting it or intending on piloting it. I'm going to go through some of them and places that I visited on my trip. However, it's not an exhaustive list, and I note that it's very hard to know what's going on in different jurisdictions, because most courts or government departments, if they're looking into ODR, we don't necessarily know it. It's up to them when they want to publish what they're doing or when they announce that they have a pilot. So I'm not by any means saying I know everything that's going on around the world. So British Columbia, the CRT, as I have said many times, is the first example in the world of an ODR system that is fully integrated in the public justice system. So it's an end-to-end online dispute resolution process, and they deal with small civil claims of a value up to $5,000. The aim is to increase that monetary limit to $25,000. They also deal with strata disputes, and there they have no monetary limit, and they are set to gain jurisdiction over motor vehicle personal injury disputes this year, as we speak, I think. In BC, several other tribunals are adopting the CRT's ODR technology. So the government, when they developed, the government of British Columbia, when they developed the online Explorer, the Solution Explorer, that they call it, the first stage, where people could go on and follow the guided pathway system. They did that with the aim that all tribunals in British Columbia would adopt that. So it would be the same across the board to make it easier for court users. The residential tenancy branch of the BC government, as well as the Property Assessment Appeal Board, they both have ODR components that are built into their services. So the BC, I found, has more ODR, they use ODR more widely than anywhere else in the world. And they also have, this is not courts, but they have the Justice Education Society over there. They provide Small Claims BC, which is an ODR platform that assists people resolve disputes without the need to go to court. So if no resolution is reached on this platform, the matters still have to go into the court system, to the provincial courts, which is, I guess, the equivalent of your district court here. They also have the Legal Service Society of British Columbia, which provides My Law BC, which is an online platform with what they call an ODR twist. The ODR twist being the dialogue tool, so there's like the Explorer tool, a negotiation platform which moves the website beyond the information orientation to one of online dispute resolution. So there's a lot going on in British Columbia in this area, and that's really where you have to look at if you're looking to implement ODR in the courts. In the United States, there's quite a lot happening, as was recently stated by Colin Rule, who is the former director of eBay, ODR at eBay and PayPal, and the vice president. He's now the vice president of ODR at Tyler Technologies, which is the largest provider of case management systems and e-filing software in the UK. He said late last year, when Michael and I shared a panel with him in Melbourne, he said that he believes that the US is about to hit a tipping point when it comes to the modernization and integration of ODR in their court systems. So he believes that they are going from an awareness stage, everyone's talking about ODR, to an actual execution stage. When I was in the US, I went to Utah, because Utah has developed an ODR system for small civil claims that is currently being piloted in one of their justice courts, the West Valley City Justice Court. And the Utah ODR system bears many similarities to the CRT and the UK models that I just went through, so the pyramid and how you go through the stages. But it's slightly different, and they have the education evaluation stage, so similar to the exploration stage. It goes on to communication stage, same as negotiation, facilitation and trial preparation, and then finally adjudication stage. And they also have a post-judgment stage to see how everything is working and if people are following the agreements that have been reached. However, during this pilot that they are currently conducting, they're only trialing the communication and facilitation stages. So they're skipping that first and quite essential exploration stage where people can go online. And I think people tend to do that, or courts tend to do it, because that's the most complex part to set up and also most costly part. So they go straight into the negotiation and communication stage, which I don't think is great, but it's good start. You have to start somewhere. Yeah, so they deal with small civil claims up to $11,000, and they have built their system in-house. In Michigan, I visited a company called Court Innovations that has developed the online dispute resolution platform Matterhorn. The Matterhorn platform is used in about 60 courts across 8 US states at the moment. They are quickly expanding across the US. So they're being used in Michigan, Georgia, Illinois, Arkansas, Kentucky, Ohio, Arizona, and Texas. So the subset of matters dealt with online vary between the states and the courts. But they're not just dealing with small civil claims, they're dealing with traffic matters, warrants, online pleas, parking issues, and family law. So it's wider than just small civil claims. So these courts that use Matterhorn have ODR platforms that they're using for specific types of applications and also for online negotiation and mediation. But they're not fully integrated end-to-end online court systems like the CRT or the Blueprint in UK. For example, I was told that in Columbus they have an online court, and I went to Columbus and met with them. So the Franklin County Municipal Court said that they have an online court, but they have integrated ODR in its dispute resolution department, which is separate from the court. And they offer mediation online as opposed to solely in a physical setting. But this process sits separate from the court, so that's important. It's separate, it's not part of the court proceedings. And if the mediation fails, the court date is still set, and you just still have to go into the court process. So it's more like mediation that's annexed to the court proceeding as forming part of the process. New York is interesting. When you look at the kind of matters that lend itself to an online court, there's a lesson to be learned from New York. So the New York State Unified Court System developed a conceptual design for an ODR platform dealing with consumer debt matters. However, the plan for the ODR pilot for this subset of cases was terminated as it became apparent that these cases they were too complex for the online environment. Because it required adequate safeguards against predatory practices by creditors, and this could not be guaranteed in an online environment. So instead what they had to do, they had to reassess the kind of cases that they should put in an online court, an ODR system, and they have now decided to go ahead with small civil claims instead of the case type that they originally considered. In New York, they also have the American Arbitration Association are using ODR to resolve no-fault automobile insurance disputes. And that's an alternative to going to court. And they said these kind of matters take about 4 years to go through court there. So doing them online in a few months is obviously very good. I think It's obviously different in different states and in different countries, but in Victoria, I think small civil claims take about 6 months to go through the whole court process, and we think that is slow, but it's nothing like America. 4 years for a motor vehicle accident, that's quite a long time. So then what the American Arbitration Association are offering is obviously very attractive. Okay, so the UK. The UK has committed about £1 billion to upgrade and modernize the whole court structure, and as part of this, they want to establish an online court to deal with low-value civil claims of a sum up to £25,000. And this blueprint is very much modeled on the CRT in Canada. However, at this stage, this is not really what they're doing. So they've done all the work and they have the blueprint, but what they are doing is that they have upgraded their old money claims online system. So this is an old system that they set up in 2002, where it's basically e-filing. You can file your claim online and you can file the response. But once that is done, it's taken out of the online environment and goes back into the court. So that's what's happening in the UK at the moment. That's not to say that nothing more will happen. It's obviously quite a long process. So whether they will implement an online court in the UK or not, I do not know. And it very much depends on who you speak to and what answer you get given. Just quickly, in the UK, the Traffic Penalty Tribunal of England and Wales, they actually have a full end-to-end online process. So they hear penalty charges and use an end-to-end online platform called the Fast Online Appeals Management System. On this system, submissions and evidence is uploaded on the platform. Any comments and clarifications on the evidence are provided over the platform, and any online messaging all communications takes place by online messaging. And then e-decisions are provided by the adjudicator without a physical hearing taking place. So it's really an end-to-end system. The Netherlands, I went to the Netherlands, they have what's called Justice for Two, which is a startup company that has created a private ODR platform to assist the Dutch population navigating the legal requirements surrounding divorce. So this platform has kind of risen out of the ashes of Rechtwijze, which was at the forefront of ODR, but which didn't succeed for different reasons. But this is an offshoot of that, and it's a very impressive system, and it guides the parties through divorce in a conducive and amicable trying to have a conducive and amicable separation with the aim of preventing long court cases. And they seem to do a really good job, and it's quite impressive. But again, this sits separate to the court. It's complementary to the courts, but it sits separate to the courts. Just quickly, 2 more things. The EU, there is a European ODR platform that allows consumers to submit complaints against European traders and merchants in relation to trade of services or goods. However, when I went there, I realized that what it does at this stage is merely assisting the consumers to select a national ADR provider. So the platform itself doesn't provide an ODR system or a dispute resolution system. It actually just points you to a national ADR provider that you want to use. So I wouldn't call it an ODR platform. And China, I did not go to China, and China has the Hangzhou Internet Court, which we heard quite a lot about at the end of last year at the conference. Again, from what Colin explained, and I do not know, but the way I understand it is it's an internet court, it's an e-court as opposed to an online court. So they use technology very differently. You actually have to go to the physical court, and it uses high-tech, state-of-the-art technologies. I believe that you go in and it's big screens everywhere, and your case is, facial recognition is used to pull out your case. And then when you file a case, you can basically talk to the screen and it types it out before you. And you can also use like virtual reality goggles to assimilate the experience in a courtroom before you go in. So these are obviously very high tech and they use technology, but it's quite different from the idea of not having to go to court. So there's a distinction there. Yes, so what's the future? I think that online courts are going to start, they're going to be implemented around the world into the public justice systems. I don't know who's going to go first and whether it's the UK. I mean, the UK has done a lot of work on this. So if they don't go ahead, we should definitely look to the UK and the work they've done instead of reinventing the wheel. So at this point, I obviously also hope that Victoria and Australia will go ahead. As to when or they will do that, I'm not sure. So New Zealand could be the first. You could lead the way. You could gain the expertise and the knowledge, and you could be the first country in the world and lead the way for an online court. So good luck.
Thank you very much, Katarina. So Mike Heron's now just going to give us the New Zealand perspective and where we're sitting at the moment.
Good evening, everyone, and thank you to Legal Issues Centre and to Otago University. It's a pleasure and a privilege to be here. Thanks, Bridgette, Ali, and others. I'm going to talk very briefly. I will be less than 15 minutes. There are light refreshments and I'm standing between them. So I want to talk about three topics. I just want to touch on what the position is currently in New Zealand as to ODR. Second, I want to say or attempt to explain why we might be lagging behind. And third, I want to very briefly say why ODR might be positive for Dunedin. That might be slightly left field, but I'll explain when I get there. The current position, if I can talk about that, it's really a game of two halves in New Zealand. The first half is the formal court system, and the second half is the specialist tribunals, and Katarina's touched upon this. In the formal court system, there's, in New Zealand, nothing really approaching true ODR that Katarina has described. It's still pretty paper-based. There are some very good initiatives with AV, with digital casebooks, etc. But I'll just give you a snapshot of the picture from the Chief High Court Judge, Justice Venning, at the recent World ODR Forum, which was held in Auckland in November last year. He said, and I'll quote him, this paper's online, unsurprisingly, I became a judge in 1995, 23 years ago. Then, when I was assigned a case, a registry officer would wheel a trolley into my chambers, stacked with several large boxes of paper files. Last week, when I was assigned my latest case, I'm still quoting, the files didn't pop up on a server or a screen, and they weren't delivered by a drone. They were still delivered on that same trolley from 1995. And if anything, the number of boxes and paper had increased, which is a little bit depressing, but Justice Venning went on to say that surely the time has come to replace our disputes tribunal, $15,000 or less, with an online court within the district court. And he gave reasons for that. He said that disputes up to that level are generally less complex and lend themselves to automated processes. They can't presently economically be brought even in the district court, our lowest court. And the use of an online court, he said, made sense. It would speed it up, reduce costs, etc., etc. Now, I absolutely agree with him. I'll add to that, though, it's something that you probably don't know. Our biggest court, and what I used to refer to as the coalface, is the district court. That's our lowest level court. And the Legal Issues Centre, one of the things, the many good things that has done, but it has highlighted to the profession a problem that exists right staring in our face in our biggest court, and it is a problem with civil access to justice. The district court, I don't know whether you know, some of you of course do, but has something approaching 170 judges in more than 50 courts across New Zealand. The bulk of their time is dealt with family and criminal cases. But the district court actually has jurisdiction to deal with claims for up to $350,000. It didn't used to be that, it was 200, but recently 350. Now, as some of you students will know, there's only a few of you here, that's a lot of money. And the vast majority of New Zealand businesses are small. Something like more than 90% have 5 or fewer employees. So if you've got a debt, and I'll speak personally as a lawyer, barrister, if someone owes you $25,000 or 50 or 100, that's a big deal. It's a really big deal. Not just for you, but for your employees and for the survival of your business. What do you do when you need to recover that? You have to go to the district court, right? So guess how many civil cases are disposed of each year by our biggest court, with nearly 170 judges across more than 50 courts? Have a guess. Anyone? Starter for 10? It's got to be thousands, doesn't it, Andrew? 642. Brilliant. Less than 700. 610, in fact, in the annual report. So either you've been reading the court annual report or you're a genius, probably the latter. And the legal issues that's about 4 per judge per year. Now, I'm not saying the judges are sitting on their hands. The cases just aren't coming. Why is that? The Legal Issues Centre told the profession last year. It was the same old reasons, same criticisms of courts generally. You know, they're too costly, they're too complex, they're full of lawyers, they're uncertain, and they take too long. It's the same old criticism. But the additional factor that the Legal Issues Centre pulled out, which I thought was brilliant, lawyers don't trust the district court. They prefer the High Court. They don't trust it. Well, that's our biggest court. Now, that's a blimmin' bleak picture, isn't it? Because there are very good judges, very good staff, very accessible courtrooms. They're everywhere. But it just is not appealing at all, and lawyers don't trust it. So the potential for ODR is not just at the low level of the disputes tribunal. Absolutely, that makes sense, but even further up into the district court jurisdiction. So that's the first half of the story of my first point. The second half of the story is the usual Kiwi, and that involves tribunals. And this is the usual Kiwi ingenuity. Let's just do it. Let's just do it quietly, and I think, Bridgette, you said by stealth. Tribunals are going much more digital, even incorporating aspects of true ODR that Katarina talked about, facilitation, online assistance, etc., online hearings. Tenancy tribunal, one example, is a good one. I haven't used it myself, but I think, Bridgette, you highlighted that, and others have. If you go onto the intellectual property, the office, IPONs, the whole thing's online. You log in, you register, it helps you through, and the hearings online. They're done on the papers, which is rather ironic. Lawyers understand that, but that means actually just digitally. And there are others. Disputes Tribunal actually is forcing you now to file online. So there's a lot happening at that lower level. But it is quite a game of two halves. So my second point, and I'll move more quickly now, is why are we lagging behind other countries in bringing in ODR? We've got this prize example in Canada, CRT. In British Columbia, there are 4.8 million people in British Columbia. How many in New Zealand? 4.8 million. And we're a common law jurisdiction, and this thing is working. It undoubtedly, if you listen to Shannon Salter, the chair, I mean, it's just transformational. it's fair to say that. The numbers they are getting, the customer satisfaction, the throughput, the resolution, and you go onto it and have a look. You can see all the decisions. You can see the stats. It's pretty, it's really impressive if you get a chance to listen. So why aren't we just grabbing that and doing it? Well, it's a combination of many factors, I think, and it's only my view. It might be a bit controversial here, so particularly, Your Honour, from the Supreme Court, if you wouldn't mind not quoting me, or I'll be struck, or I'll be... But in my view, it's inertia, it's fear of failure, it's a lack of courage, and it's a failure of leadership of all of us. Because to incorporate, as Katarina said, ODR, true ODR in the court system, that requires heaps of thought, requires plenty of money, it requires careful testing, it requires evaluation, etc., etc. And what do we have in New Zealand that's a bit of a standout? We have a 3-year electoral cycle, and that's short. We have humans that do big jobs, ministers, chief executives of departments, and they don't like failure, like all of us. And big IT projects, as Katarina said, they are risky, expensive, and they have a history of failure. So that's one really powerful factor. And I've talked to those, and I was on the the Ministry of Justice Courts Transformation Project on their advisory board, and the answer was, we are not going to do Big Bang here because it's just not going to be tenable upstairs. It's just not politically feasible. But the other reason is, frankly, lawyers and judges are averse to change. We are change resistant. We just aren't good at it. We've spent years learning the rules of precedent. Now, that's not a good starting point. It's in our DNA, really. And when you think about why are online services in all these other areas, why are they so successful? It's because they make it easy for the customer. Think about your banking, your travel, your government services now, you're registering a company. Think about even your healthcare now, getting your repeat prescriptions or the like. Why are they so successful? Because they're easy, and they're efficient, and they're intuitive, and they explain it to you, and they help you through it. Not always, but the ones that get there and work do. What does that require? A hell of a lot of investment, a hell of a lot of work, and a lot of change. And the leaders, I include myself, when I was a leader, the leaders of the court system, both politicians, both judges, both lawyers, etc., they just are not willing to seize that opportunity. It's too risky, too hard. But don't panic. We have a new Chief Justice who I have incredibly high hopes and huge faith in. She's an amazing individual. We have a new Chief Executive of the Justice Department who I know well. I admire him a lot. And even if they don't believe in this, the digital wave's just going to swamp them, and it's going to happen. It's just going to happen eventually. You cannot have a situation that Justice Venning talked about of 23 years of paper files being wheeled in on a trolley. It just won't survive. The young people will just go, "You what?" So, my third and final point, and I'm just about there, is why could this be good for places like Dunedin? Well, my tiny embryonic ODR company, Coda, uses Dunedin lawyers, Dunedin experts, to supply some of its online services. Why do we do that? Because Dunedin has excellent lawyers, it's got a great law school, it's got fast internet. You are Gigatown, I think. And you've got relatively low overhead. So you've got to be realistic about this. That really counts. So the opportunities to bring the national legal market to a place like Dunedin strikes me as obvious. It allows lawyers, ODR that is, and others, well, for one thing, to escape the Auckland traffic and to escape Jaffas generally, if you know what Jaffas are, Aucklanders. So you just, and this is, if I just give you one little example, in Coda, the one area, or one of two areas that we are finding some little success with is in relationship property, where the separating couples are quite reasonable. Just to give you an example, it takes, from filing a relationship property claim in our family court, it takes you on average 2 years to get to a hearing. 2 years. Imagine the grief and the money. Now, if the couples are reasonable, they can come onto our site, get an automated agreement, draft it themselves, learn bits about it from the site, ask questions, get information, and then certify that so it's legally binding and take a digital copy or a printout off to their bank and their lawyers to register the transfers. They can do that all online for less than $2,000. Split, that's $1,000 each. They can do it within 2 weeks. That to me is the power of just a tiny bit of ODR or something like it. So for all those reasons, I'm very keen on it, and thanks again Legal Issues Centre, Otago University, for giving me this opportunity to talk to you. Good evening.
Great, thank you very much, Mike and Katarina. So we're now going to take questions. So if you want to pass your questions along or just wave them loudly. While they're coming up, I will just ask one thing that sort of came up from the end of your talk, Mike, is the idea with what Justice Venning's talking about being this sort of inertia in the court system, and that it won't survive if we keep having that kind of inertia. And I noticed in Katarina's report, she talks about the risk to courts of if we have too much of the private ODR, that they will be shielded from that pressure, that maybe that's dropping our filings and might be part of the explanation for the district court because these other privatised services are being offered. What do you think about that as a sort of constitutional principle?
I would support that. I think from my experience, private ODR is not the answer. It's definitely not the answer, and I say that sort of against the interests of my little fledgling startup, but the reason it's not the answer is you have to compel people to use this to make it work, and that was the Dutch experience. It failed because they didn't make it mandatory, I think. And you've got to start small, you've got to make it mandatory, and you've got to get it into the court system itself to give it the kind of imprimatur, all the things that the court brings. And to me, that will just add to the mana of the courts. Courts are a great place to do heavy-hitting criminal, constitutional, and big regulatory, but small civil, really?
Okay, I'll let you give you the mic. She's got a whole stack of cards there.
So this is a question for you, Katarina. Who creates or updates the evaluation stage decision trees? So who says what a close family member is? And then what duty of care or liability attaches to providing that information, i.e. a lawyer's duty to advise?
So this is obviously a very important question, because the evaluation stage, seeing it's being provided by a court, it's essential that the legal information provided is correct. And obviously, the law changes all the time. There's new legislation, there's new case law coming in. So the court has to be responsible for that and be responsible for it being right. And that's why it's essential that legal experts in that very field are used to create this system. So it constantly has to be updated by the court. And the court is responsible should they provide the wrong information. So it's very important that this is done right and that legal experts are used. They can recognize that there might be loopholes here. This is the legislation, but actually, if someone went and get legal advice, we could get around it in a different way. And if that is the situation, I was told by a member of the CRT in Canada, Darren Thompson, that it's essential that the online court, the online site, actually point that out. This is the law, but you might need additional legal advice on this very issue.
Next question. If people don't trust the district court offline, why would online help? Surely specialised judges are the answer to that.
That's a good point. Specialist judges, I think, that's a controversial topic all of itself, but I agree, specialist judges. I mean, in some ways, ODR properly done in a court is giving you specialist information as you go along, and specialists at the various levels of kind of facilitating you to resolve things, and then giving you help to mediate, and then ultimately adjudicating. So that'll be a good question. Good question as to whether trust would be built. I don't think it can get worse than 610, but I might be wrong.
This is a question for Katarina. So many people around the world don't have access to internet, and how did you see the jurisdictions using ODR provide for those people? Okay,
so this is obviously, I think that's the most, the greatest concern around the world is about the people who don't have access to the internet, and even statistics say that most people have access to the internet. So if they don't have access to a desktop, they have access to the smartphones. So that's the first thing. If you create an online court, it has to be adopted to smartphones so that everyone can use it easily. However, even if you have access to the internet, that doesn't mean that you are able to confidently conduct an online proceeding online. It might be that people use the internet every day to go and check Facebook. That doesn't mean that you're confident to actually navigate a court process online. So what I say that we have to do in Victoria if we adopt an online court is that use the example that I saw in Canada and in California. They have self-help centers in their court. They don't have online, in California they don't have an online court, but they have very good self-help centers where litigants in person can go in and they actually get helped, they get assisted to navigate the system. So instead of having a parallel paper-based system, which some people say we have to have two systems in order to not marginalize people, I say we should not have that. You have to go online, it's mandatory, but the courts have to have self-help centers where people can come in and they help them fill in the pages of the online process and guide them through. So that's very important. And that's obviously quite tricky, like in Victoria. Of course it will be set up in the Melbourne Magistrates Court, but what about the smaller courts in the countryside? Will they have a self-help center? So this is a very important issue that people get the proper assistance. So self-help centers, I say.
Yeah, I think to add, one of the concerns in New Zealand is that if we do it the way we're kind of looking like we're doing it sort of through the back door by stealth, is that we'll then say we've got it up online, so now we've got access without doing that front end, that actual assistance or providing that that assistance that people need to be able to interact with it.
I've got one more question here. This is for you, Mike. You mentioned the success of property relationship cases on CODA. What are the things or the types of cases that aren't working?
Well,
almost everything else.
Yeah, well, I mean, that's almost literally true in a way, but the ones that just don't work, we get a lot of inquiries, but anything that's too complex, anything that has too many parties, anything that, I guess if it's well, the two areas, relationship probably, which I've talked about, the other one is where it's a small civil dispute, might be 100,000, and the parties don't want to travel, that we see some success in, even with online mediation of it. So I think, yeah, its complexity doesn't work well. We've had a huge range of ages, particularly in relationship probably, so it's not so age, but demographic probably, region probably, access to internet, I would imagine, all those things.
And I was just wondering, so in New Zealand, in Māori culture anyway, there's a sort of principle of, face-to-face interaction, of the idea that it's important to have that face-to-face interaction. When you were, on your church or travels, did you come across that concept of people talking about the need to have that kind of personal confrontation, or something that we've experienced with AVL being introduced into the criminal courts, is that people are disappointed by, the victims are disappointed by not having the opportunity to go in and eyeball the accused in court because they're on a screen, so they don't get that confrontation, which sounds like a bad thing, but people sometimes want that. Is that something that you had any discussion over?
Yes, I think it requires a cultural shift to realize that you don't need your day in court for every single issue you have. And I think there's quite a distinction here between the civil jurisdiction and the criminal jurisdiction, because I wouldn't even raise online court and ODR in relation to the criminal jurisdiction, because that would be shut down very quickly. In Australia now, in Victoria, we're using a lot of video links from appearances, bail applications, criminal hearings, and that's quite controversial to not have the accused come into the courtroom and actually face the court. So I think criminal is definitely a later stage, if ever. But when it comes to civil disputes, small civil claims, do you really need your day in court and see the other person when you're arguing over $3,000 or even $25,000? If you can go online from the comfort of your home, and it's a simple system, and you follow the steps and you resolve the dispute quickly, without the stress, and cheaper, that is better. But it probably requires a cultural shift, because people have this, well, I see you in court. So you have to, change your mindset and realize that the involvement of a judicial officer is not necessarily necessary for all disputes.
All right, well, if there's no further questions, we've got one. There's one being waved up the back. In the meantime, I'm just noting that when Katarina said at the outset that of her talk, that getting it right from the outset is really important for the court design. And here at the Legal Issues Centre, we're very much of that principle, and we're conducting a project at the moment. And I know there's quite a few lawyers in the room. We're still looking for participants in our online court study. You get to interact with a mock version of the CRT. So we've taken the CRT, developed it into a portal, and you get to have fun playing with a mock client. You get an actor who will talk to you. The people who've done it have really enjoyed it. It's a great experience. We need people who have some litigation experience of at least 3 years in practice. So please spread the word. We've also got CPD forms here for people, and the recruitment information for our study. Now we've got one more further question.
This one's from a fan of the Disputes Tribunal. It says the Disputes Tribunal is about a 6-week wait list and has one hearing. So does ODR not build in more delay and more cost for the court with extra processes? And so is the small claims court not the best place in New Zealand?
That's interesting. The 6-week wait is great news, and I think one of the, well, we could get into a discussion about whether the disputes tribunal is something that vindicates legal rights or reaches pragmatic, fast, just low-level solutions, and I don't know the answer to that. But if there's a 6-week wait and people can get in there and sort it, well, that's great news. I wouldn't be suggesting getting in the way of that. I just query if that is the case nationwide. Brilliant.
Okay, well, without further ado, I'd like you to join with me in thanking our speakers very much for a very interesting evening discussion, and join us all in Seminar Room 5 for refreshments. Thank you.